Hello, good morning, and welcome to this 9th annual Employment Law Breakfast Briefing. My name's Ian, and I head up the Employment Law team here at Field Seymour Parks. Obviously slightly different from our usual surroundings at this time of year, so we're broadcasting live from the glamorous location of my spare room, rather than Green Park or the Law Society or the other venues we've been at in the past. So apologies, no breakfast included this morning, but you're obviously welcome to make your own. But otherwise, the format's going to be quite similar to what we've done in person before. So session will last for about an hour and 15 minutes. I'm going to be trying to cover some of the key topics from last year and indeed looking forward, things you need to be aware of in respect of employment law development. Sadly, you're all on mute. It's nothing personal, just the only way we can really sort of handle the numbers on a session like this. But please do type in your questions into the question box on your control panel, and then I'll open that up at the end of the session and basically try and answer as many questions as I can in the time that we've got. And I'll also ask you to participate in some polls as we're sort of going on to get your views on different things. So please do get involved with that, which is good. It's good for me to get a little bit of interaction rather than just speaking into a camera. If you want a copy of the slides, they'll get emailed to you afterwards, but you can also download them from the handout section on the webinar platform. And at the end of the session, there'll be once I shut it down, there'll be a short feedback form for you to fill in. If you can do that, would be really appreciated. We do try and make these events as useful as possible, so your feedback is genuinely welcomed. And we will do what we normally do, in that we'll draw one lucky winner to get £50 worth of John Lewis vouchers from an electronic hat, I guess, this year. So I will get us started. Normal caveats on these things apply in that. Particularly with this session, it is a bit of a whistle-stop tour. So if you do need advice in any of these areas, then please do get in touch and we can discuss your sort of specific circumstances. But let's crack on and have a look at what we're going to be looking at today. So these are the topics we're going to be covering. Brexit, subject I seem to have been talking about at these sessions for a number of years now, but it is not only have we left the European Union, the transition period has ended as well. So I'm going to take you through what that means, what the impact is on employers as a result of that. Then going to talk about furlough briefly, really just sort of summarising where we currently are with the scheme, so what the current rules are. Won't be going into that in masses of detail because obviously it's a subject that's been covered at length before, but there are some recent changes you need to be aware of. Then hopefully what might be one of the themes of 2021 is that hopefully as the pandemic eases and there is an increased return to offices and workplaces and people leaving their spare bedrooms, then going to highlight some of the potential legal difficulties or things to be aware of as and when you are trying to encourage employees back into their normal place of work, or indeed requiring them to return to their normal place of work. A couple of cases we'll then look at on interim relief and collective redundancy consultation. New off payroll rules to talk about as well, which come in April. I say new, they were due in April 2020 and were delayed, but we'll summarise what's required there. Piece on the public sector. And some restrictions on exit payments, and then I will gaze into my crystal ball and give you some idea of what I think might be in the pipeline for 2021. I have to say that comes with quite a big disclaimer, as in this session last year there was no mention of furlough, no mention of coronavirus, so I obviously failed quite miserably this year. So if I equally fail to predict any other major developments, I have to accept no responsibility. Before we crack on into our first topic, I want to get your views. So we'll start off with a poll talking about 2020. So what I would like to know is, what was your #1 HR priority in 2020? So you're limited to 5 options, I'm afraid, and you can only select one. And please vote as and when you are ready. You should be able to click in straight away. But was it restructuring and cost cutting, recruitment and retention, change in working practices, well-being or mental health, or improving skills and performance? I suspect that some of you want to click on an other box or all of the above box. I haven't given you those, I'm afraid, mainly because I want to force you into choosing one thing so we can sort of see if there's some themes really. And as you might guess, once I've got you to vote on this, I'm then going to get you to have a go telling me what your priority is for the coming year, just so that we can see the challenges that lie ahead, I guess. Right, let's close that down. Now you've all had an opportunity to hopefully, and let's look at the results. So quite an interesting split, really. So obviously, cost cutting and restructuring, I half expected that to be maybe number one, and I guess it's good news that it isn't at the top of the list, but I guess it's also an indication that the coronavirus pandemic hasn't just brought with it the problems of cost cutting. You know, you've got those changing working practices as well, so maybe that is the increased flexible working, and obviously we all know the impact this is having on people's mental health, not just obviously through the workplace, but through all the other restrictions and everything else that comes with the pandemic. Well, that's interesting. So I'm going to contrast that now, and we'll go straight into another one, because I want to ask exactly the same question, but for this year. So again, if you can just let me know what is currently your priority for 2021. So I need you guys to gaze into your crystal balls now and tell me what your main challenges are for this year. I'm kind of hoping, although we'll see, that this is going to be a slightly more positive outlook, and we're going to see restructuring slightly lower down, maybe more some of the more positive aspects of HR sort of kicking in as the challenges for the coming year, as we all hope that the vaccine rollout and everything else allows us to get back to some semblance of normality, at least in the second half of the year. So still a few votes coming through. Thank you very much for getting engaged with it as well. Makes me aware there's somebody at the other end of the camera, which is lovely to know. Right, let's close that down and share the results. Yeah, so this is interesting. So restructuring and cost cutting still there, obviously as a factor for a number of you, but you can see those bottom 3 elements getting a good split. So changing working practices, again, a key issue. Well-being and mental health, again, you know, that's not going away. And then again, that skills and performance. So obviously we talk about some of the developments coming this year. Hopefully, you know, when we're talking about changing working practices, the section we've got a little bit later on return to sort of workplace and sort of the reduction in home working will be of help to you. But right, let us move on. Let me close that down. And we will move on to Brexit. So as I say, this is something we've talked about in these sessions over a number of years now, probably 3 or 4 years, I guess it must be. So there's 3 main aspects I want to talk about, really. One is to deal with a couple of concerns that were around before we had Boris's deal at the end of the year. So to just sort of cover those off, and then to look ahead in terms of what we anticipate being the impact on employment law and on employment regulation going forward. But to start off with a couple of sort of specific topics, personal data. So there was some concerns about the ability to transfer personal data to and fro from the European Union after Brexit went through and after the transition period. We've got a little bit more clarity on that. So firstly, for transferring personal data from the UK into the European Economic Area, which, just as a reminder, is all the countries in the EU, plus Liechtenstein, Norway, Iceland, and also Switzerland fall within this category as well. Basically, the government has said for the next 4 years, they are basically saying that that is permissible and there's no need for any additional safeguards. So UK into the EEA is fine for at least 4 years. Slightly different position in terms of transferring personal data from the European Economic Area into the UK. We've got this idea of a 4-month bridge, which is really an extension of the transition provisions, basically say that you can continue to transfer personal data into the UK for that period of time without any additional safeguards, and that may be extended to 6 months. The idea being that during that period of time, hopefully the European Commission will grant sort of an adequacy decision, which is basically it saying we are satisfied that the UK has essentially equivalent protection for people's personal data, and therefore, despite the fact it's leaving the European Union, it can be sent over without additional safeguards in place. If that doesn't happen, then businesses that transfer personal data from the European Economic Area to the UK will need to put in place additional safeguards before that period ends, which could be model clauses, it could be corporate rules, different options there depending upon what you're doing. You would think it would be almost automatic that adequacy decision would follow. Hopefully it will. Obviously, we have pretty much just implemented GDPR. The one question mark is on our surveillance practices and whether the European Commission will want some reassurances or safeguards in that area. But the hope will be that adequacy decision will come in, and therefore we won't have that issue of transferring personal data between the EU and the UK and vice versa. Couple of other things to then pick up on. Obviously, freedom of movement, right to work in the UK changes from the 1st of January. So basically EU citizens arriving from that day onwards don't have an automatic right to work in the UK. So they'll have to have a right to work in the same way as everyone else who arrives from elsewhere in the world. And that may well be under the new UK-based immigration system. So if you do want to employ EU workers going forward and they're not already in the country, then it may well be you need a sponsor license. And my colleague Imelda Reddington, who deals with our immigration matters, would be happy to discuss that with you. For those who are already in the UK at the end of the year, they do still have a period of time to make those applications for settled or pre-settled status, so they can continue living and working in the UK until the 30th of June for that. And just briefly on right to work checks, you can still rely upon a European passport or ID card until the 30th of June. So despite the fact that the status or the ability of EU workers to work in the UK changes from the 1st of January, you've got this sort of grace period until the 30th of June where you can continue to rely upon sort of the old checks of checking passports. And then a final point I will mention here, just because it's convenient, not related to Brexit, but for those of you who have been using the slightly relaxed regime for right to work checks during this period of the pandemic, just a reminder that currently, as and when those measures end, you will only have 8 weeks to carry out your sort of retrospective right to work checks. Now, there is some lobbying of the government to try and get rid of that requirement, because it's going to be pretty onerous for those people who've onboarded a lot of people during the pandemic, probably the last thing they need to be doing. But as it currently stands, that is still required. You've still got this 8-week period to get those retrospective checks done. Right, so that's the first couple of bits of Brexit. I'm going to ask you a question now on sort of the slightly longer term implications. So, again, rough and ready question, really. Please vote as and when you're ready. But will Brexit result in less employee protections, more employee protections, less protection in some areas and more in others, or no difference at all? So yeah, pretty broad answers. You might want to give a more nuanced reply. Unfortunately, I can't give you that option under the polls, but it'll be interesting to see what you say. We asked this question actually at the sessions last year, or a similar question at the sessions last year, and the outlook at that point was that it would be broadly the same or slightly less. So it'd be interesting to see if any of you have changed your views on that as things have progressed over time. Let's close that down then, giving you a chance. Share the outcomes. So, so nobody thinks there's going to be more employee protections as a result. A third of you basically think there'll be no difference. And then the remainder of you, so probably two-thirds really, isn't it? Think it'll either be less or more in some areas and less in others. Well, I'm not going to entirely give you the answer to this, to be honest, but I am going to talk about what the legal framework is for it. And I'll also leave you to come to your own view. So this very question hit the sort of the press on Friday. Some of you may have seen. Financial Times ran a report that there were plans to rip up EU labour market rules, which was then instantly rebuffed by the Secretary of State for Business, saying they're not going to lower the standards of workers' rights, go further than the EU in some areas, which is true, and looking to protect and enhance workers' rights going forward. So I suspect the balance is somewhere in between. I'll let you come to your own views on who you prefer to believe. The detail of the Financial Times report, they did acknowledge that it hadn't yet been agreed by ministers or the cabinet. Were proposals being put together by the business department, and actually, when you read the details, seem to be around removing the 48-hour maximum working week and the recording obligations, changes to rest breaks, and some changes to the calculation of holiday pay. So, not saying those things aren't controversial, but certainly not ridding us of all EU employment regulation. So before I get drawn into assessing whether or not the government are going to live up to what they say, I'm going to get back to safer ground and talk about the law. So what are the legal restrictions, I guess, on us changing employment law that is derived from the European Union? Well, broadly speaking, your starting point is that a snapshot of European Union law was taken as of the 31st of December of this year, and that is then basically sort of converted into domestic law and remains binding as domestic law going forward. And that therefore includes decisions of the European Court of Justice. So if any decisions, any judgments were handed down before the 31st of December or up to and including the 31st of December, they are binding on us in the same way as they were before. The differences are that there is now a process whereby the Court of Appeal and the Supreme Court can depart from those European Court decisions if it is right to do so. So those are in simple terms, those are the two top tier of our sort of civil court system. And if a case reaches up to that level and they believe it is right to divert from a European court decision, then they are free to do so. Likelihood is that they are probably going to focus where they think decisions are wrong in law, and it will obviously take some time for cases to get up to those sort of those higher courts as well. We won't be bound by future European Court decisions, so anything from 1st of January onwards will not be binding, but you may still see them reported. You know, we may still comment on them in our updates, etc., because they may have an impact on the approach our domestic courts will take to interpret legislation. So that's the broad position. You then have the deal that Boris reached on Christmas Eve, the Trade and Cooperation Agreement, sort of the free trade deal, call it what you like. And that places some potential further limits on the ability to sort of reduce employment law protections. So firstly, there's this idea of non-regression, so that both parties, this is, are saying that they're not going to step back from the protections that are already in place as of the 31st of December in a manner that will impact trade or investment. And what you have to bear in mind is that these limits are in place to try and ensure that if there are going to be these elements of free trade, that there is something of a level playing field. So there's this commitment to maintaining existing standards, and then there's this sort of second linked element that if significant divergences come about between the UK and the EU regulatory regimes in future, that has a material impact on trade or investment, there's this idea of appropriate rebalancing measures, which is likely to be tariffs, in short, tariffs on goods. So it doesn't stop the UK changing its employment law or regulations, but it indicates that there may be implications for us if we do so in a manner that, as we say, has this material impact on trade or investment. So a lot of it turns really upon the political appetite for trying to reduce employment regulation. And I suspect that what we are most likely to see is not a bonfire of regulations with immediate effect, but maybe slow changes, sort of salami tactics, bit by bit changes, because the UK is unlikely to want to jeopardize the trade agreement it's got in place by doing something that has this material impact. So, you know, getting rid of, for example, the agency working regulations is probably going to be considered a step too far at this point, but maybe some of those amendments to the working time regulations or to the calculation of holiday pay, that is all much more possible and indeed likely to be permitted. So in terms of action required for sort of employers from an employment perspective related to Brexit, not much really. It's a watch in brief. Obviously be aware of the personal data piece, aware of the right to work in the UK, but in terms of employment law changes, it is much as we currently are, and it's just keeping an eye on developments. One specific point I mentioned, if you've got a European Works Council, that will be impacted by the end of the transition period, and you should take specific advice on that. But that's a whole topic in itself, so I won't get further into that now. So I think that's probably enough time on Brexit for now, and I'll move us on to the equally joyous topic of coronavirus and the furlough scheme. So I'm going to ask you a question again, basically asking which statement best describes your approach to furlough, so the coronavirus job retention scheme. Are you using it currently? Have you used it in the past but not using it at the moment in time? Haven't used it at all to date, but plan to do so in future. Not used it at all and no plans to use it. And your final option is, what does furlough mean? Which you can select if you've been lucky enough not to have to engage with the concept. Yeah. Be interesting to see not only how many of you have used the scheme over the past year, but equally the likelihood of anyone looking to use it in future. And we'll obviously talk about the terms of the scheme currently. Right, let's close that down and have a look at your answers. There we go. So nearly half of you still utilising the furlough scheme, which I think is probably what I expected, in that it has been a very useful tool for employers. It has been very widely used, as you'll have seen from the statistics in the press. Another roughly 20% have used it in the past. So you've got really sort of 2/3 who have utilised it. And then another third who haven't used it at all and obviously have no plans to do so going forward. Quite interestingly, that doesn't look like we're going to have many people who are going to be utilising it going forward who haven't used it in the past. So it's kind of those who have already utilised it continuing to use it rather than people new to the scheme. As for the 2% who are saying, what does furlough mean? I'm not going to have time to explain that to you in full today, but obviously if you do have any questions on it, you'll have to let me know. Right, well, let us move on and talk about where we are with the scheme as it currently stands. So again, I'm not going to get into the full details of the scheme, but there are a few key points, particularly from claims from the 1st of December, you need to be aware of. So the scheme has now been extended until the 30th of April of this year, and the government contribution has now been fixed or guaranteed to that period as well. Which is 80% of salary up to £2,500. Employers still having to pay employers' NI and pension. You may remember there was an original suggestion when it was extended that it would be reviewed in January. That's been dropped and essentially will remain at those rates until that end of April date. You don't, as an employer, have to have used it before to use it going forward, and indeed you can furlough employees who have not been furloughed in the past. There's no limit on the numbers you can furlough, and indeed flexible furlough, so the idea of sort of using it for supporting part-time working, is still an option. The most recent developments and the most important ones to be aware of is from claims from the 1st of December, you can't use furlough to basically sort of subsidise a contractual or statutory notice period. So what a lot of employers did earlier in the scheme was have an employee on furlough for their notice period, normally topping up their pay in full, but basically claiming back what they could for the government. There is now a prohibition on that specific one to say that you can't claim from the scheme while an employee is under notice. And also, if you have accessed the scheme from the 1st of December, then you will be published by HMRC to say that you have done so with some reasonable indication of the value of your claim is the HMRC wording, but some sort of band-ins, I suspect, are likely in terms of how much you've claimed from the scheme. So for some employers, that's given rise to concerns about sort of adverse publicity and the like, but essentially it's part of the HMRC sort of anti-fraud measures, which also include letting employees know when furlough has been claimed for them as well. Other thing to be aware of, the job retention bonus, which was due to pay out in February. Very simple terms, you're going to get £1,000 as an employer for each employee that you had kept on who you had previously furloughed. That has been postponed or possibly scrapped because of the extension of the furlough scheme. It is possible that something different may be reintroduced in due course. It didn't get the best publicity, so it may well be that it is quietly scrapped entirely, but certainly not relevant at the moment. Right, so that's furlough. Let's look forward a little bit, and I want to get onto this point of return to workplaces. So the sort of the reduction in home work, and again, please vote as and when you're ready. But can an employee refuse to commute to their workplace because of fear for their health? Again, I'm not giving you the options of very nuanced replies, but it's yes, no, or maybe are your options on this one. So essentially what I'm saying is can they refuse to commute without sort of being subjected to less favourable treatment or maybe being dismissed because of their commute? So not the workplace itself, but because of their commute. A couple more moments just to get your votes in. Let's have a look. All right, let's close it down. So mixed, 55% of you going for always the best answer, which is maybe. You can never go wrong with that, really, can you? 37% saying yes, and 8% of you thinking no, that's not permissible. Well, I'm not going to answer it right now because I'm going to deal with that now in our sort of next section that I'm going to talk about, which is some of the things you need to bear in mind as and when you're trying to get employees to return to their workplace. Now, obviously, this is an issue that some employers grappled with during the course of last year, and indeed, I'd anticipate we would have that again as and when the sort of restrictions start to lift. Some of you may still, of course, have it now because home working isn't permissible, but I think it's going to become a hotter topic as we move forward. So different things to consider. Starting point is obviously the current COVID regulations. In very simple terms, the current lockdown is basically an extension of the Tier 4 restrictions as far as workplaces are concerned to the entirety of England. Basically, you're meant to stay at home, save that you have this exception where it is reasonably necessary to leave home for the purposes of work and where it is not possible to work from home. There is a caveat on that for the clinically extremely vulnerable. If they can't work from home, they should still not attend work. But that's your starting point. Check out the latest regulations. They will obviously change. They change all the time. But you will need to keep an eye on that just to see if there are restrictions that your employees will say, well, here's legal grounds on which I cannot attend the workplace. Other things to think about. First thing I would say, which sort of underpins all of this, is there is a term implied into every employment contract, which many of you may be familiar with, which basically says that the employer cannot act in a manner which is calculated or is likely to cause a breakdown in the relationship of trust and confidence. And basically, the law says for an employment relationship to work, there needs to be trust and confidence between employer and employee, and therefore, as an employer, you've got an obligation to ensure you don't act in a manner which breaks that relationship. Now, in very broad terms, you'll see this sort of principle across various different parts of employment law, but the key principles with it are that it can place some limits on your express contractual rights. So the fact that in the contract it says your place of work is X, full stop, you've still got an implied duty to not break this relationship of trust and confidence when sort of imposing that obligation. So it doesn't necessarily stop you doing it, but you'd need to make sure that the general principles are that you've given good notice to the employee, you've discussed or consulted it with them, and you've got justification as to what you're looking to do. So it's not a reasonableness test, but there is an element of that to it. And if you do breach that term of trust and confidence, then you can end up facing constructive dismissal or indeed constructive unfair dismissal claims if the employee's got 2 or more years service. So always think of that. Other points to think about, obviously you have various health and safety obligations, including now in respect of COVID secure workplaces. So there are regulatory issues there if you haven't complied with that. Equally, obviously, if someone is injured as a result of you failing in your duty of care to them, for example, getting sick, then you could end up facing personal injury claims as well. So 2 very good reasons why legal reasons why you need to comply with those sort of health and safety obligations and make sure that you've got COVID secure workplaces. Now, that leaves us on to the point from my question, really, which has got a lot of publicity in the press lately, which is about Section 44 and 100 of the Employment Rights Act 1996. And the principle behind these is that if an employee is absent from work because they have a reasonable belief that attending work would put them in serious and imminent danger, and they could not reasonably be expected to avert that danger, then they get protection from detriment, i.e. being treated less favourably, or being dismissed as a result. So where it definitely applies is if they have a reasonable belief, so it is their belief, doesn't necessarily have to be a fact, but if they have a reasonable belief that attending work would put them at serious and imminent danger, then they can say, well, I'm not going to attend the workplace, and they would get protection as a result. Now, they have to have that reasonable belief. There has to be the serious and imminent danger. So there are a number of sort of hoops that have to be jumped through, but it is something to be aware of. It's received a lot of publicity recently, particularly with teaching staff, unions were talking about relying upon these sections when schools were going to be opened up, or were opened up after the Christmas period, and they were going to rely upon these so their members didn't have to attend work. But they could have wider use than that. Going back to my original question on travel, well, we don't have a definitive judgment from the courts as to whether or not it would cover a commute into work. However, if you look at the case law we have to date and the way the courts have interpreted the Act, what I would say is it is likely that an employee could claim that it covers their commute. So if their commute, they have a reasonable belief that their commute is going to put them in serious and imminent danger, and they can't avert that danger by most obviously walking to work or maybe getting in their own personal car, then they could use that as a basis for refusing to attend work. The key with this is, again, it goes back really to that implied term piece. You need to consult with your employees. You need to understand what their issues are. And obviously, to the extent that it's reasonable, you may need to take steps to avert the issues. Right, moving on. Other issues to think about in terms of getting employees back into the workplace. Disabilities. So obviously there's some specific government guidance on the clinically vulnerable and the clinically extremely vulnerable. But just be aware that disabilities can and indeed do extend beyond that. It is anyone who has a physical or mental impairment that has a substantial adverse impact on their day-to-day activities that has lasted or is likely to last for 12 months. Essentially, if you've got a condition that is impacting on you day to day and is lasting for a substantial period of time, there is a risk your employee will qualify for protection as a disabled employee. It can include mental health issues. So if someone suffers from anxiety, then you may need to bear that into account when assessing the impact on them of you requiring them to return to the office. And there's a whole host of sort of disability discrimination claims employees could consider: indirect discrimination, discrimination arising from disability, and perhaps most importantly, you have an overriding obligation to make reasonable adjustments to ensure your employee is not at a substantial disadvantage. So you need to be thinking about adjustments you can potentially make to ensure your disabled employees are not disadvantaged by your requirement to, for example, return to their normal place of work. Again, justification is key, particularly if you're looking at claims discrimination arising from a disability. Being able to justify your requirements you're placing on that individual are important. Childcare commitments, you may need to take those into account as well. This is the cue for my two children at homeschooling downstairs to burst in and demonstrate my point quite nicely. But your main legal risk on these, obviously there's practical pieces. If people have childcare commitments, you may find it difficult to get them into the office, and how many staff are you prepared to lose? But also there's a potential claim for indirect sex discrimination. So women statistically are more likely to have primary childcare responsibilities. They are therefore more likely to be disadvantaged by requirements to attend work rather than maybe homeschool, be at home. And therefore, if you can't justify that practice, that's another claim you could potentially face. A couple of final things to rattle through before we move on to something different is whistleblowing. So we've seen this in the employees are seeking to rely upon complaints that they have made about their employer's approach to the pandemic, whether it's opening up of offices, whether it is requiring people to attend work, whatever it might be. And when they complain about these things, they then later on say, well, actually, that was a whistleblowing disclosure, and you have treated me less favorably, or you've maybe selected me for redundancy, you've dismissed me as a result. And I've summarized briefly what the protection can be on there, but that's just something to think about. If you have got employees raising concerns about what you're doing, obviously, A, like any allegation of that nature, you need to take it seriously, but B, you also need to be aware or think about the possibility that employee may rely upon that in future to try and claim that they qualify for protection as a whistleblower. Final thing to note, flexible working requests. Just as and when you're in discussions with employees, don't forget that they do have a statutory right to request flexible working. I've put on the slide the things that need to be ticked off for it to qualify as that type of request, i.e. needs to be in writing, needs to be dated. They need to make it clear that it is a statutory request or legal request, set out the change sought, the impact that's anticipated, and give details of any previous applications. But if they do all of those things, you then as an employer are under an obligation to consider it in a reasonable manner, basically follow a formal process to have considered it, to discuss it. If you turn it down, there are statutory grounds you have to rely upon, and you've got to get that all done in a 3-month period at the latest. So just be aware that there isn't an employee has sent you a flexible working request and you haven't quite spotted that that is what it is, because failure to follow that process can give rise to claims in itself. Right, we're going to move away from Brexit and COVID. Talk about maybe some more sort of classic employment things to be aware of. Couple of cases need to give you some details of. First one is this one of Steer and Stormshaw from the Employment Appeal Tribunal. This was decided just before Christmas, 21st of December. And as some of you might be aware, in certain types of cases, most commonly in whistleblowing cases, if you bring a claim before the tribunal, you can make an application for interim relief, which is basically to say, I should be reinstated into my old job, or an alternative job should be found for me, and you need to do this now because I am likely to succeed with my claim, and I need to be basically back in my job until such time as this is fully resolved. And that process is very onerous for employers when it comes up, because you have to move very quickly. The claimant has to do it within 7 days of issue, and then the hearing gets listed very quickly. It's normally decided within a matter of weeks. Now, it only applies to certain automatic unfair dismissal claims, but this case concerned whether or not it should be extended to all discrimination claims. Currently, there is no interim relief available in discrimination claims, but what the Employment Appeal Tribunal said in this case is actually that's incompatible with the European Convention on Human Rights, particularly the right to a fair trial and the prohibition on discrimination. And they've sent the case up to the Court of Appeal and basically said that there should be a declaration of incompatibility, which is really where the courts say this law doesn't work with our obligations under the European Convention on Human Rights, and the government needs to then go away and do something about it. Now, this isn't impacted by Brexit, because we are still signatories to the European Convention of Human Rights despite leaving the EU. And in any event, in Boris's deal, in the Trade and Cooperation Agreement, there is a specific reference in there to interim relief still being available to claimants. So what you need to be aware of here is that if as and when maybe this interim relief becomes available to people claiming discrimination, I think we're going to see a whole lot more use of it, and it's going to place a lot of obligations on employers to deal with tribunal claims very quickly, and that's particularly important considering some of the backlog we've got on claims at the current time. You'll see later on I'll talk about a new employment bill that is pending, and I wonder, which is my own personal speculation, but I wonder whether the government may include within that interim relief for discrimination cases. That bill's likely to be published later this year, so we may find out sooner rather than later. Next case I want to talk about is a European Court of Justice decision. So this is one of these cases that was decided before the end of last year, and as such we are still bound by it until higher courts or the government says otherwise. Now, this relates to collective redundancy. I did a specific webinar on this topic back in November last year. So if you do want more details of this case, or indeed collective redundancy, otherwise you can find that on the website, and I've put a link in the slides as well. But in simple terms, as and when an employer is proposing to make redundant 20 or more employees over a period of 90 days or less at a single establishment, so these sort of larger scale redundancies, there are obligations, increased obligations to inform and consult and to notify the Secretary of State. Now, what you've probably picked up from that paragraph is that our domestic law, which basically brings into effect the European law, is forward-looking. It looks at proposals. How many are you proposing to make redundant? But what this European court decision said is actually, no, that's not right. At the point every single employee is made redundant, at their point of termination, you need to look forwards and backwards, basically whichever rolling day, 90-day period has the maximum number of redundancies in, that is the period you need to consider whether or not, when determining whether or not your collective consultation obligations are triggered. Now that sounds, you can probably just about understand the rationale for it, in that they're trying to make sure there are sufficient rights to as many people as possible. But the problem is it creates issues with the number of redundancies that may have already been carried out, the people who have already been dismissed. Because if they've already been dismissed, quite difficult to sort of inform and consult with them, and you may only know that your obligation has been triggered after the event. So it causes quite a lot of practical issues, which the European Court didn't give us any guidance on how to deal with. My advice would be two things, really. One is to be cautious, that if you are in any doubt as to whether or not you're going to trigger these obligations, that you consider doing so. So just follow the process so that you are covered. It is also still permissible under our law to stagger dismissals so that you never actually tip over the required numbers. So that's something to consider as well. Although that won't work for redundancy situations where you need to move fast or the numbers are so large it's just not possible. Right, moving on, because I'm conscious of time and I do want to leave some time for questions at the end. New off payroll rules, IR35. Again, this is a subject we dealt with a couple of times in the past, actually, because it was due to come in April 2020. These changes were delayed and will now come into effect on the 6th of April of this year. Again, I've got a link in there to the past webinars. They're still available, and we've got a specific one on there dealing with these changes, which is in much more detail than I'm able to go into today, so do check those out. But in simple terms, the purpose of the original sort of IR35 legislation was to prevent the avoidance or reduction of tax by using sort of intermediary companies. So in its most simplest form, an individual, Joe Bloggs, has his own company, which he's the sole director and shareholder of. Let's call it Joe Bloggs Limited. And Joe Bloggs Limited then provides services to an end client and receives payment of his invoices into that company. And then Joe Blogg takes the money out of that company by paying himself dividends rather than paying himself a salary on which PAYE and deductions and national insurance deductions would be due. That's in its simplest form. And the reason Joe Bloggs might do that is that it used to be quite tax efficient to do so. The purpose of the IR35 rules was basically to ensure that people weren't able to use these intermediary companies as a vehicle to basically sort of avoid paying tax, whereas if it wasn't for that company, they would be an employee and would be taxed normally. Now, so that's the position as it has been the case for a number of years. The changes, so from the 6th of April 2021, they apply to the private sector because similar rules were introduced into the public sector a number of years back now. And what these changes do is they shift responsibility for operating IR35 from that intermediary, from that personal service company, from Joe Bloggs Limited, to the end client. And the reason being is HMRC doesn't think that these personal service companies are properly accounted for their tax, so they're getting somebody else to do it instead. Doesn't impact small companies, and I'll give you an indication on the slides who will fall outside the scope of this. But on the basis we're short of time, I thought I would focus on the actions you might need to consider. Firstly is to work out whether or not you are exempt as a small company. If not, you then need to do a bit of sort of due diligence digging to work out if you've got individuals who supply their services via a personal service company. And also think about there might be more than one company in that chain. There might be an agency in the chain as well. You then need to carry out this idea of status determinations, which is basically to work out, would the individual providing the services be an employee were it not for the contractual arrangements with their company? And there's an online tool, SES tool with HMRC, which a number of you will be familiar with, which you can use, or you can do your own analysis. You then need to communicate those determinations to the company and to the individual. So basically telling them whether or not you think they fall within scope of IR35. And as part of that, you may then want to consider changes to your contracts or the nature of your relationships with these individuals. For example, would it be better for them simply to be an employee going forward? Do you need to structure it slightly differently so it's less likely that IR35 will apply? Different things to think about. And then going forward, obviously review your sort of template contracts to make sure that they are taking into account the new regulations. But also you might want to make sure you've got a tighter grip on self-employed engagements in future. It's historically been the case that employment contracts are quite well regulated, normally only issued by HR department or whoever's got responsibility for it. Self-employed relationships less so, and they can sometimes be issued by almost anyone. You're going to need to be careful on that because you're going to potentially need to do the status determination at the start or before the start of every contract. So you need a bit of a process in place. Right, well, as we've been talking about private sector changes, it's only fair, and I know we've got some people on the webinar today from the public sector, I talk about some changes that impact on the public sector only. So these are sort of restrictions on public sector exit payments, already in place, applied from the 4th of November of last year. And essentially, they seek to place a cap on the maximum termination payments that can be made to public sector employees of £95,000. Within that, very broadly, includes redundancy payments, compensation payments, and payments in lieu of notice if they are greater than a quarter of annual salary, so large pile-on payments. Excluded from the cap is holiday, death in service, sort of personal injury type payments, and smaller payments in lieu of notice not exceeding a quarter of annual salary. It's relaxed. There's some specific relaxation for certain claims, 2P, discrimination, whistleblowing, and in other areas. But yeah, that's broadly something to be aware of. If you're in the public sector, you're probably already up to speed on it. One thing I would say is not to get these regulations confused with the plan to introduce a repayment scheme for exit payments. So there is a proposal to compel employees who leave the public sector but then return within 12 months to repay some or all of the exit payment they've received. That is still yet to be brought into law, so we don't have that as of yet. Okay, right, to finish us off before I get on to some questions, a few things to talk about that are in the pipeline, although it is difficult to give detailed guidance on them as of yet, as we sort of await further information. But the government currently is undertaking consultation on non-compete clauses. So it started in December. I think it runs into February, so still got time to engage with it if you want to. But it's about the clauses that are in employment contracts that say, for example, after your employment has ended, you shall not work for a competitor for X period of time. Now, the government did a consultation on these types of clauses a number of years ago, basically concluded from that they weren't going to do anything with it, but they're looking at it again, basically with a view to try and ensure that these types of clauses are not stopping people from taking new employment or starting new businesses, which is obviously a priority for them, particularly with the impact of the pandemic and probably trying to get the economy moving this year. So they're consulting on a variety of different proposals. The main one, I guess, is about the idea that whether or not the employee should be entitled to compensation for the duration of the clause. So this is a concept that is common in a number of European jurisdictions, Germany and Italy, I believe, whereby despite the employee's employment ending, if you still want them to be bound by a non-compete clause, you have to pay them a sum of money for the duration of that clause. So the government's asking basically, is that a good idea? And if so, what or roughly what should be the level of that compensation that is paid, probably with reference to the previous annual salary. So is it the full annual salary? Is it a lesser sum? They also have this idea of having greater transparency at the start of employment. So basically saying restrictions will not be enforceable unless they are entered into and sent to the employee and the employee agrees them before they start employment, which sounds like a lovely idea, but does cause some issues as often these restrictions are only really imposed as and when people reach more senior positions. That's the appropriate point to impose them. So it would seem slightly odd that you had to do it at the start of employment. It almost might be encouraging more restrictions at the start of employment because you won't be able to introduce them later on. But anyway, it's out for consultation, so we'll see what people say. Possibility of some just caps on the limits of the length of restrictions. So maybe saying you can't have anything longer than 12 months, 9 months, 6 months, 3 months, whatever it might be. Is that a good idea? And also the possibility of them being prohibited entirely. Should say that other forms of sort of post-termination restrictions are also under review. So you would commonly have restrictions on the ability to solicit or deal with customers, interfere with suppliers, solicit or employ employees, all sorts of things. They're also under review as well, which makes sense because actually sometimes those other restrictions can be just as prohibitive on competition as a sort of a classic non-compete clause. We wait to see what they choose to do about it. It's quite a tricky area, I would say, and I wonder whether or not they'll have the appetite for it, because basically the case law is that's being built up on sort of post-termination restrictions goes back many years, and obviously as soon as you start to interfere with that by way of sort of statutory regulations, the greater likelihood that you end up with more confusion than there is currently. So, but we'll see. We will see. The other point is we expect a new employment bill to be published. So this was in the Queen's speech in December 2019. Obviously hasn't been progressed much since then for obvious reasons, but we do expect that it probably will be published this year. May not go into effect this year, might be more realistically looking at April next year, but we expect we'll get more details and the proposed bill published maybe in the latter half of this year. And just a reminder of some of the things that were planned back in December 2019, which feels like a very long time ago, is to bring in a single enforcement body for sort of labour type issues. So currently you've got split responsibilities between HMRC, Health and Safety Executive, other government bodies. There's a plan to bring in a single enforcement body for that, which is also probably in line with the trade and cooperation agreement that's been reached with the EU. The right to request a more predictable contract. This goes back to 0 hours workers and the like, to create a legal right for them to go to their employer and say, well, I don't want to be on a 0 hours contract anymore. I want greater certainty of my hours. Devil in the detail on that one to see whether it is just a right to request or whether it is actually a right to demand. Extending pregnancy redundancy protection, so currently just applying during the period of maternity leave, looking to extend that from when the employee notifies their employer of the pregnancy, orally or in writing, or to 6 months after return, so to give those enhanced protections from redundancy for a longer period of time. Possibility for additional neonatal care leave, which is for essentially parents or carers of babies who have had to go into neonatal care, so premature babies primarily. And there was some suggestion there'd be an additional 12 weeks paid leave. Have to see how that interacts with existing rights such as maternity leave and shared parental leave. This idea of flexible working by default, which is probably, although they talked about it back in December 2019, is probably very topical in the current climate. But essentially, under the current flexible working scheme, which I talked about earlier on, employees have to make a request for flexible working, and the employer has various grounds on which they can turn it down, but the onus is really on the employee. The idea behind this is you switch it round. So actually the employee has a right to flexible working unless the employer can establish good grounds as to why otherwise. There's also a suggestion, which isn't on the slide, of some potential leave for unpaid carers, so people who maybe look after elderly dependents. But we wait to see on that. Expected to be published at some point this year, but I can't really comment much more on that because we need the detail of the bill. Other thing I will mention, which again isn't on the slide, you will get the normal sort of increases in national minimum wage, national living wage, etc. in April. So I will pause now to take some questions before sort of the end of the session. So if you haven't already done so, please do type them into the question box, and I will do my best to answer as many of those as I can. Having a look at it, there's quite a few. So if I don't get to them all today, we will. I'll have to follow up with some of you individually. As I say, once we've got through the questions, I'll close the session down. If you can then fill in the feedback form, that would be brilliant. Give you a chance to win those vouchers. And also, if you do want to keep abreast of developments or the other events we've got coming up over the years, there's an option to get details of those in that form as well. Right, let me get this questions box open. Right. So first question I've got here is on EU nationals, and can we ask currently for details of pre-settled or settled status at this moment in time? Because you may recall from what I was saying earlier on, obviously you have this grace period through until June where you can just rely upon the sort of the passport, but that obviously doesn't give you an indication as to whether they are going to be carrying on working in the UK beyond that period. The short answer in this is that you can't compel employees to tell you whether or not they have settled or pre-settled status, or to give you evidence of it, and you can't treat them less favourably as a result of them refusing to do so. What you can do, and I would probably recommend that you do, is ask for them to provide it voluntarily. You need to be careful in that if you do so, you do it in a non-discriminatory manner. So you probably need to have a sort of a blanket policy to make sure that you're not selecting people on the basis of their names or something of that nature. But yeah, asking for it on a voluntary basis would make sense, because it might help you judge the likelihood of those employees being able to continue to carry on working in the UK. But yes. Let's have a look on the questions. Yeah, ask a question about precautions when staff have actually wanted to work in the office because they prefer to do so, because of limitations or issues with home working. And I guess how do you cover yourself as an employer? Well, I guess the first piece is you go back to the original pieces on the COVID restrictions. So you need to be careful that you are falling within the scope of those restrictions. So currently, obviously, talks about working from home unless you are sort of unable to do so. So you need to make sure that there are grounds on which these people are not able to do their job properly from home. And you might want to have that recorded somewhere. The other thing I think I would be thinking about, just from a risk perspective, is you'd probably want it to be clear that this is essentially not something that you are compelling them to do, because ultimately you don't want any suggestions, as I talk about later on, that they change their mind at a later date or the relationship in some way deteriorates. So you might want some sort of record to make it clear that this isn't something that you've forced them to do sort of against their will. Question on making offices secure, but yeah, a common issue in sort of tower blocks, you have an issue with the lift, and do I imagine that the rules on distancing might be relaxed for those purposes? So I guess you can go into a lift for a short period of time and then with sort of obviously without the social distancing and allowing people back to work. To be honest, I don't know. It's very difficult to say. I think a lot of it, we are sort of dependent upon sort of the vaccine rollout, protecting those who are at higher risk, and that then making the government more comfortable with removing or releasing some of the restrictions. And it may well be that things like that are looked at. So yeah, I think you just have to wait and see on that. Can you postpone flexible working requests until the situation becomes clearer? Well, the short answer is that you could have a discussion with the employee and see if they are willing to do that. If they are not, then you would have to follow the process and reach a decision as best you can at that point in time. Now, it may well be in an employee's best interest to delay it. If that delay means it's more likely that their request will be granted, because generally speaking, you can only make one request every 12 months. So when you make your flexible request as an employee, you kind of want to make sure you're picking your best possible time, and so it may well be that it's in their interest, and you can agree with them that the period is extended, but you can't insist on it. Question on the Marclean case about consulting with employees who have already been dismissed. Well, this is the piece we kind of need further guidance on, and we probably need some further decisions from domestic courts. But there is a risk, which is what the question is about, that because you are assessing whether or not your collective consultation requirements, because you're assessing them at the point of dismissal of an employee, there is the possibility that you will conclude at that point that you should have collectively consulted, and that might mean that you can pause your process with that employee and then carry out that process for them and indeed any others going forward. But what it doesn't help you with is those that you may already have dismissed. And there is no principle under sort of the idea of a consultation is with a view to agree and trying to avoid redundancies, mitigate the impact. If you've already dismissed someone and they're not still in their notice period, that's very difficult to do. So you've got this real contradiction in the law, and all I can say is that in reality it's going to be highly unlikely you're going to be able to go back and adequately consult with someone you've already dismissed. Your focus is probably on those going forward, and in the event you did get a claim about that, I think we would have to run some arguments to say that the value of that claim should be nominal on the basis that you weren't aware of your obligations until much later, and there wasn't anything else that you could do about it. question here, yeah, on the tribunal system, which is a good question, which I haven't talked about today. But how is the employment tribunal system coping with the current pandemic? Not particularly well, I think it's probably fair to say. It was under pressure before the pandemic. It has adapted. We do now have remote hearings operating. They've changed some of the regulations to allow decisions to be made quicker, and not everything necessarily to have to go through a judge. There's sort of more judges online than there were before, so it is adapting, but we are still seeing some serious delays in certain areas. So it does differ from tribunal centre to tribunal centre. Some seem to be coping with it better. Others, we've got very serious delays. For example, periods of over a year to just get to a preliminary hearing, so not even the final hearing. And it does link in with that interim relief piece, in that if that becomes available, then that's going to be quite an attractive remedy for claimants, because they might be able to get their case heard in weeks rather than what be months or even over a year possibly. Yeah, are we obligated to follow EU legal developments? Just can't. So I guess this is new laws. So if the EU introduces new laws in due course, do we have to follow them? You go back to this divergence piece and this material impact on trade or investment. So the EU regulations that are currently planned, we will not be bound to introduce them. They are also in areas where we already have a pretty decent domestic system, for example, in whistleblowing. But yeah, we're not obligated to do everything they do. But if there becomes this serious divergence between the two systems, that's when you get into this possibility of these measures being taken, possibility of tariffs being imposed. Will the furlough scheme be extended further? I think a lot of it probably depends upon how the pandemic is going. As we've seen, the extension of it has often come hand in hand with the expectation of how long restrictions are going to be in place. I suspect that they will be looking to bring it to an end at the end of April. But that said, they have tried to do that before and it hasn't quite worked. Can an employee work from home if that is their preference? Well, if you agree to it, they can. If it is purely just their preference to work from home and they are able to work into the office under the restrictions and all the other things I talked about earlier on, then you could reach the stage after you've consulted with them that you could compel them to come back into the office. I think that the thing I would say on all of these home working or return to the office points, discussion with your employees and communication with them is key, because if you can communicate them what you've done with the office, how you've made it secure, what you've got in place, you can talk about what their concerns are, you can see how they might be able to be resolved. From a practical perspective, obviously that may work in resolving the issue, but also from a legal perspective, it will flush out whether or not they are claiming protection or likely to claim protection under any of those sort of legal heads that I talked about earlier on. So, and obviously the more that you explain the steps that you've taken, the less likelihood the employee can claim that they've got a reasonable belief of serious and imminent danger, or that they've got a reasonable belief that there's been a breach of some form of legal obligation. We're not going to get through all these. I'll take a couple more and then I best close it down because I do want to try and finish on time. Expected impact of the off payroll working on the private sector. Well, we wait and see, I guess, really. When these were brought into the public sector, you did see a decrease in the number of people using personal service companies and supplying their services that way. Some people have said that is because the public sector is more risk averse than the private sector, but I suspect you will see particularly larger private sector organisations wanting more certainty that they're not going to have IR35 issues with their suppliers, and therefore may be looking at alternative arrangements, increased use of employed staff, or requiring people to work under a different arrangement, like under an umbrella agreement or something like that, to ensure that they don't have those IR35 issues in due course. Yes, it's a good question, which I will finish on. Will the additional protection to pregnant employees extend to other rights? So I think the question is relating to other family-friendly rights. So this is under the employment bill, so we do wait and see what it exactly looks like. But the intention, as I understand it, is that there will be extensions to protections from redundancy, not only to those who are pregnant and for 6 months after they're back from maternity leave, but that extended sort of period, will also apply to people who are on adoption leave or on shared parental leave. Now, shared parental leave is a little bit more complicated because that can be taken in blocks potentially, but yes, the intention is to extend it that far, but let's wait and see what's actually in the bill. Right, I think we're at our closing time, so I'm very sorry. I can see I've got a number of questions I haven't got to, but I will try and email or get back to you to give you some guidance on those. Unfortunately, we're a bit short on time. But thank you all very much for attending. Yeah, if you can just hold on one moment to complete the feedback form, that would be brilliant. And yeah, hopefully I will speak to some of you soon. Thank you very much.